Joining us tonight from our studios in New York City, criminal defense attorney Matthew Maddox. He's a good one. Matthew, great to have you back on the show. Let me start with what Ronan Farrow was talking about. And this is really, to me, is ugly. But you've got the prosecutor's office, and they had a case a couple of years ago, before the proverbial stuff hit the fan here with Harvey Weinstein. But they didn't pursue it. Now they are pursuing it. From your perspective, what's going on here? You know, how does a DA decide when or when not to pursue charges against something? Is there something about public pressure that actually can impact a DA?
Well, Vinny, you know as well as I do that public pressure and journalism, media coverage can move a district attorney or a state's attorney to take action that maybe he wasn't or she wasn't going to take earlier. It is up to the prosecutor's discretion, as you know. But I give credit to Mr. Farrow. I give credit to his energy and to the extensive and really impressive work that he and his team did do. And look, it's just a fact of life, unfortunately. Sometimes it's media coverage, sometimes it's journalism that can spark the wheels of justice to begin moving.
Okay, now let's take that issue and put it in the middle of a trial. And my guess is you could have a defense argument that the only reason they're bringing this case is because of all the hoopla in the media, and you take that same fact and turn it against the prosecution.
Well, look, much remains to be seen, right? Trials, as much as attorneys think, we all think that we know what's going to happen in a trial. We do our preparation. We're diligent. Trials, the thing about trials and what makes them so dramatic is that oftentimes things don't happen the way we think they're going to happen. So if the defense is going to angle their closing or angle some of their approach on this in the way that you're describing, Vinny, they've got to be very, very careful that their case comes in and that the case is produced to the jury in a way that will support that argument, right? They've got to be very, very careful about that.
Yeah, because you are acknowledging that there's lots of accusers out there. But, I mean, there's going to be a bunch of accusers in testifying in this case. I think we'll have about 6, we believe, will testify. So would there be any acknowledgement of it? You're going to have all these people outside. It's the elephant in the room. It's part of jury selection where, you know, people have heard about it and they're trying to see it. They'll still be fair and impartial. Do you think that the defense at all tries to acknowledge it, embrace it, and use it?
Look, if it's in jury selection, then you've got to obviously you've got to ask questions about that, right? You've got to make sure that your prospective panel doesn't come in already prejudiced because of media coverage. Absolutely. And as much as possible, I think we all try to, in trial, get ahead of issues, produce those issues, or explain those issues to the jury so that we are in control of it, so that we're producing that, and we're not on kind of the defensive, if you will, by the opposition talking about certain issues. So yes, I think you want to come out and be proactive and be ahead of that element in this case.
Rich McHugh, who worked with Ronan Farrow in this investigation, spoke to Ted Rollins here on Court TV and talked about an issue that I want to talk to you about, which is casting couches and that whole cliche thing that those of us outside of Hollywood, you know, think we know about. Take a listen.
Anybody who's worked in TV news we'd heard rumors for a long time that Harvey had been. There were always just rumors about Harvey and women, and I don't think we'd heard like the level of detail of what actually was we unearthed eventually. But by the time I think it was 2016, the end of 2016 came around, my partner at the time, Ronan Farrow, we decided that we wanted to do something with the Oscars, the upcoming Oscars, and we were kind of sniffing around for a topic, and we decided let's take a look and see if casting couch is still applicable in Hollywood today, and that was basically the genesis of it. We interviewed Rose McGowan. She had been talking about it for a long time. She hadn't named him publicly, Weinstein, but she had, earlier in 2015, and she had been preparing herself for this moment. And so when we reached out to her in early 2017, she agreed to do an interview with us. And when she named him, it was like the gloves are off. And that was really the beginning.
All right, Matthew, let me ask you about that cliche, the casting couch. In this case, the defense, we believe, will be consent, that all of this activity was consensual in nature. So exactly, do you think the casting couch issue plays a part here, him being a movie producer and some of these folks being actors? I mean, how does this play, and which side gets the advantage?
Look, I think unfortunately people, they kind of devour these sordid details, and they like to think in a very expansive and imaginative way about what happens on that casting couch. I think that, if this were a trial that happened, if this were happening 10 years ago or 15 years ago, I think that casting couch scenario weighs more to the benefit of the defendant. But I think what has happened here in the Weinstein investigation and now in jury selection and this Me Too movement, I don't think that presumption about what happens between directors and producers and stars or starlets, I don't think that is any longer going to be a factor that weighs in favor of a defendant. In fact, I think that power dynamic, if it is used effectively, that power dynamic is probably going to be used to the benefit of the prosecution in this case.
All right, how will the defense cross-examine accusers? What will be the tone of that cross-examination? Will it be accusatory?
I'm glad you asked that question. I've tried sexual assault cases, and there is a method to do it, and you don't cross-examine alleged sexual assault victim the same way you do a hardened cop or other witnesses. There is a method, there is a demeanor, there is a tone to go about this, Vinny, which has to be deliberate, it has to be methodical, and it has to be one which, if you can do it, you convey a note of almost regret as you bring your witness through these cross-examination questions. There is a tone of regret as you go through the narrative of your questions that does not have to be accusatory. In fact, it is not accusatory at all. It is simply bringing them through the narrative in a way where the attorney is expressing a degree of, almost very, very subtle sadness, so that you're not necessarily antagonistic, but you are still eliciting this narrative and the story that you want the jury to hear.
Matthew Maddox, always great to have you on the program. Appreciate your time tonight. Thanks so much.